Judge.
Mr. Palacio, you're now charged with a new case. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes. On February 5th, 2025, the officer was dispatched to a stranded vehicle at the 700 block of North Sam Houston Parkway, and the officer observed a car parked on the shoulder and a driver asleep at the wheel with the engine running and the car in park. The officer knocked on the window to wake up the driver, who woke up and refused to comply with the officer's command and drove the car 6 feet forward. The officer then requested the defendant exit the vehicle. The defendant put the vehicle in park, then drive multiple times before finally exiting the vehicle. The defendant was detained upon exiting the vehicle, and the officer relocated to a gas station where the defendant was observed to be dazed and confused and did not realize he had been asleep at the wheel. The defendant was also unable to communicate where he had been or where he was going. The defendant was asked to perform standard field sobriety test, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 1 out of 4. The defendant was read the DIC and declined to provide a sample. A blood search warrant was signed and executed.
I'm going to find that there's probable cause to go forward with the case. Can you look to see if he has any prior DWIs, and does he have a valid Texas driver license?
He does have a valid driver's license, Judge, and we
Oh.
did file for the ALR hearing.
And then I see he has a dismissed DWI out of Fort Bend, but no other DWIs.
There's no probable cause in that case.
I'm now ordering you, well, the first thing I'm going to do is I ordered you on your first case not to consume alcohol or illegal drugs. You've now picked up a DWI. Guess what happens now? I'm revoking your bond.
Judge, I would like to address that. So he does realize that this is a problem at this point, and he has enrolled himself in IOP and does have a meeting this afternoon to do intake for IOP, and I do have that email.
I can't show him preferential treatment. It's on any case here. I ordered not to do something. He did it, picked up a new case. You're staying with me. And I'm going to tell you now, if I find that you consume alcohol again, I will put you in a rehab facility myself in the jail. And if you respond well to treatment, it's a minimum of 9 months. Do you understand?
Yes, sir.
I'm now placing a restriction that you're not to drive any vehicle that doesn't have a guardian interlock on it. You're not to consume alcohol, illegal drugs, and Casey, I'm now going to probably give him a curfew. In the BMV, was he out in the middle of the night? Alex?
This is Your Honor.
I think it was after a bar closed. He was just sleeping in the owner's vehicle.
There's one consistent problem, and there's one thing that centers around every single problem that you have. What is that one problem? Right. You and alcohol do not mix. And I don't know what we need to do to get you to realize that, but I don't know. I hope that this is it. If it's not, it's going to be rather lengthy. Maybe that's it. Is it prison? I don't know. But all of the issues center around one thing. And I hope that you now realize this and do what you need to do. Because if you can't take care of it yourself, I will do it for you. And I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
Okay, it goes with you. And then when he comes out, or when he does bond out, he's going to have to come back for bond conditions, and then we'll carry it.
Sign his bond conditions today on the non-revoked case, so they'll be active.
Okay.
And then do they want a device other than the ignition interlock?
No, just, what time was,
The time that it took place, is the only time the officer gave is when they got the blood samples, and that was at 7 a.m. So sometime prior to 7 a.m. But he doesn't say how long before the blood was actually drawn.
what do you think about a curfew?
Judge, if I may, he is active military. So he is Still reporting to that. They're also looking to get him help. He has enrolled himself in IOP, so he does have a job
I
in the
won't
military.
put the curfew, but if he picks up a new case,
I understand. We had a big conversation and he's the one that took it upon himself to realize that this was a problem. And he told me that he was gonna use his VA benefits to look into the IOP at this point, so. He
Alright.
did send me that email that he is confirmed to begin enrollment in IOP.
okay, so, on the DWI, just pick whatever date you have.
Okay.
When he does bond out, he'll get a 7-day setting.
Mhm.
Whenever day that you get, just let Ramona know or Victoria, and then we'll give you that day. Just feel free to email them and then we can carry them.
Just put them both on the same
Yeah.
day.
Okay, all right.
I think we addressed his bond. Bond.
I was gonna set it at 5,001. That's what I normally do.
Okay. Thank
Okay,
you, Judge. I
yes,
just wanted
ma'am.
to make sure that happened.
Okay, thanks. Sorry, Ms. Finn.
I just filed a revoke and raise. He picked up a murder charge.
Yes, sir.
Wow.
This last week. This is the young guy that, he is.
How old is this kid? What happened?
17.
17, he picked up a murder case. What happened?
From my understanding, it was a weed deal gone wrong.
Oh, I read about this, right? Really? I'm so disappointed, Mr. Jones. I can't tell you how disappointed I am, you know? We've got but one life to live, just one. You don't get you don't get multiple chances, man. You're not a cat. I'm bringing you out here because we're talking about you and it's only fair that you hear what's going on. Because you've now picked up the murder case upstairs, the state has asked me your bonds are now set at, on both of your cases, on your assault and your criminal mischief, they're both set at 5,002. They did not give you a PR bond on those cases, and the state has asked me to revoke and raise those cases because you are a danger to our public. You've not made bond on those cases, so I'm going to deny their request to revoke and raise your bond. But I'm going to tell you now that I don't know if you're going to get out because your bond is set at $250,000 upstairs. But if you do, I don't want you to go anywhere. I want you absolute home confinement, 24 hours a day, 7 days a week. Do you understand? And you will have a GPS monitor, no drugs, no alcohol, no weapons, anything else?
No, Judge. Not from the scene.
And I guess just keep me in the loop what happens upstairs, you know, if they do anything with the bonds, just keep me in the loop so we can kind of stay close. The other thing is that thing's going to take a while to play out. And I mean, I'm not going to hold it for 2 years for it to play out upstairs. So let's try to find some kind of resolution so we can, you know, they can worry about it upstairs and then we can just, okay?
Yes, sir.
I'll obviously give you a sufficient time. Is discovery complete? Because these cases are from November. They're old.
We're still waiting on body cam, dash.
I mean, that's not good. I mean, wait a second.
November. It's
I guess they may have been 2Bs though. Let me see if that's right. Because if there were 2Bs, then
Actually, Judge, it looks like we have. It looks like we have all of the body cam. It just wasn't complete. We have the 911 calls.
oh, so you've got discovery's complete.
It looks
Okay.
like it, yes, Judge.
Have you given offers on both of the cases?
I have not, Judge, but I'll take a look on his,
There was an offer, but it's been
There-
rejected.
there
They
was-
Canceled out that option, that offer.
we had offered a 13-month deferred. I revoked it, obviously, with the new law violation.
Sure.
So I'm probably just gonna check his credit and put a jail time offer.
Okay, so I'll give you some time, take a look, speak with Mr. Jones, what he wants to do. The cases are kind of old, so when we come back the next time, you must accept the offer from the state. Otherwise, I'm going to set your cases for trial here. You understand? Okay, man.
But Judge, in all honesty, I can let him know right now, considering that he has a murder case, I would be reluctant to plead him guilty to an assault case. because that could be used in punishment. He's in enough trouble. We may as well set for trial if there's not going to be a dismissal on this case.
I'll speak to the felony. I mean,
Sure.
the murder was just filed a couple of days ago, so I'll speak to the felony, see what the CW wants on the assault.
So let's set it a week
And look
out.
at it.
Talk to felony,
Yes,
see
Judge.
what they want. In a week, we can set it.
Yes,
Yeah,
sir.
okay.
Right.
All right. Good luck, guys.
Thank you.
Does he have any prior DWIs, Alex? Do you know if he has any prior DWIs? Okay,
No, Judge.
Are not that we're working on.
I'll run his full NCIC if you'd like.
please.
Yes,
You
Judge.
need to understand that DWIs are big business in Texas, you know? Watch the news. Every single day, someone dies from a DWI. That's why they have made the penalty so darn severe. A third DWI, you're looking at prison up to minimum 2 years in prison, a maximum of 10 years in prison. You now
This is where the entire courtroom energy shifts. We just went from misdemeanor level consequences to a murder charge. And notice how even the judge pauses. That silence says everything. One bad decision doesn't exist in isolation, and now every prior case matters. Let me ask you this. Should past mistakes influence bond decisions when a new violent charge appears?
what you're doing is you're pleading guilty to this offense. The DWI is going to go on your record. It will be there for the rest of your life. And what you need to understand is that whenever you get pulled over now in the future, first thing an officer does is they're going to look at your record. If they see that you have a prior DWI, a prior PCS, and they come up to you and they smell alcohol, they smell any kind of funky smell, what do you think they're going to do?
Take me out of the car.
No, not just take you out of the car.
Take me to jail.
Probably so. You know, from now on, you're facing a minimum of 30 days in jail for any new cases that you pick up. No more proverbial slaps on the wrist. Do you understand?
Yes, sir.
If I were you, even if you have had a sip of alcohol, I wouldn't get into a car. It's a humongous risk that you're taking. You understand? What you have worked out is 180 days in jail to be probated for 1 year. As part of the conditions for you to complete this probation successfully, you must do a DWI education class, 2 victim impact panels. You must also do what's called a TRAS. This is an evaluation to see what conditions you may need. They assess other conditions like, supportive outpatient treatment, intensive outpatient treatment. You must also fulfill those as well. No drugs, no alcohol, guardian interlock, no breath test refusal. What that means is that if you're pulled over in a car, an officer asks you to submit a breath test, you must do it while you're on this probation. If you don't do it, you're in violation. If you violate this, I'm going to issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out. We're going to talk if you violated your probation. If you do, you're looking at 180 days in jail. Do you understand?
And so it would also be a minimum of 30 days, and we discussed that on this case if we, so it would be a 30-day minimum.
Is it here?
So he's doing 30 days as a condition.
Sorry, we're pleading to,
I think it's the enhancement.
pleading to the.
Say it again?
For reason, to the enhancement.
Oh, I see. Right.
He is aware that it would be 30 days minimum.
Right. So if you are revoked, it's a minimum of 30 days in jail. That's what they're trying to allude to. Do you understand?
Yes, sir.
I don't see the enhancement on here, so let me see. Is it true or untrue that you had a Class A misdemeanor theft in 2018?
It's true.
It's true, the enhancement. All right. You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this, you are stuck with this until you complete it successfully or you get revoked. You understand?
Sir.
You still want to do this?
Yes, sir.
How do you plead to the offense of driving while intoxicated? I will find you guilty. I'm going to send it to you to the agreement. Does this also take care of the case upstairs?
Which would be discussed in the case description.
They're going to dismiss the felony case upstairs. This is a great deal for you because anytime you can avoid a felony, you're winning. But you have to understand that there's only so many times, that they're going to do this where they're going to dump one in exchange for the other, especially a felony offense. It doesn't happen over and over.
Understand.
Do you understand?
Sir.
All right. Now, I want you to understand one more thing that, as I said earlier, DWI is big business. There is a $3,000 surcharge that we normally apply to cases like this. This is your first offense. I will waive your fee now. But if you pick up another DWI, it is a $6,000 surcharge. And if you don't pay it, every $100 you owe, you sit 1 day in jail. So you can imagine how much time you'd be doing if you pick up another DWI. You understand? We all make mistakes. But the idea is that you don't continue to endanger other lives by making these stupid mistakes. Get a clue. Good luck to you, Mr. Drew. All right. Thanks, Josh.
Judge, approaching on Jeremy Frazier's, he's on the jail docket.
Okay.
He has a felony pending that's on the docket for tomorrow for retaliation out of the same incident. He has not received any bond conditions yet. The complaining witness, we verified that she's moved out of the location. His house, which is what was on the protective order. The protective order, I think they're modifying to delete the address restriction
Okay.
and whatever bond condition.
He's not made bond yet. Yeah, he's not made bond yet though, right?
No, his family's made bond. They posted the bond. They paid the bond. The bonding company hasn't posted the bond because the court date hadn't changed from today yet. He's gonna make bond this afternoon.
I got it.
They're
Okay.
gonna post the bond this
So,
afternoon.
guys, do you mind, he's here, right?
He is
Do you
here.
mind bringing up Mr. Frazier, please? So tell me who's the complaining witness in our assault case, if you don't mind.
The
please.
complaining witness is his girlfriend, Judge.
Okay, are we still no contact with this person?
No contact, no weapons.
Okay. So your lawyer's asking for me to modify conditions of your bond.
What's up?
There's a protective order that has been issued in this case. So that protective order is still in place. The only thing I'm changing is I'm taking off the residential restriction so that you can go back to this house.
Thank you so much, Judge.
Everything else sticks. So
Roger that.
no weapons, no contact with this person. Do not pick up any new cases and just behave yourself.
Roger
You
that.
know what I mean? It's not hard, right?
What's up?
Okay, do you mind printing me out a copy? please? The MOAB on Mr. Frazier so we can modify. The only other thing I'm going to ask you to do is, it appears from what Carl has told me that your family is going to pony up the money for you to get out.
Yes, sir.
You got to comply with the conditions of whatever bonding company that they're doing, because if you don't, they'll surrender the bond and a warrant is going to issue. You also need to remain in contact with Carl, because if Carl tells me he can't get a hold of you because you're ducking and dodging and you pick up any case, I'm going to revoke the bond. You understand?
I know you don't play, Judge. Yes, sir.
Okay, great. So, right? Okay, so I think we're good. We'll have you put back. I'll give you a copy of the amended order for protection, and then after that, you're good to go. All right. Good luck, Mr. Frazier.
Their bond conditions also just a protective order.
Well, yeah, we'll have to make sure that the bond conditions is so that,
As long as they reflect it. All right, thank you, Judge.
yeah. Okay, thanks, Carl. Good morning, Mr. Black.
Morning.
So your lawyer is asking me to set you a bond. I don't know. I've never met you before. I have to get to know you in a very, very short time. I need to know several things before we set you a bond. You are an inherent flight risk because you're wanted out of another state for some charge I have no idea for. So we're going to get to know you to see whether we should set you a bond or not. I don't know at this point. So Amy, tell us about Mr. Black.
Your Honor, he's wanted out of Rockdale County, Georgia for possessing, displaying false ID with government logo or seal for criminal act, and also a theft by taking of a motor vehicle. State's opposed to a bond at this time. We also see that he has a bond forfeiture in Harris County, and then he also has an open warrant in Kansas for a failure to appear. Furthermore,
Did you know that?
She just told me when we were waiting on him to come out.
we have concerns about how he would even get back, considering his driver license was denied renewal in 2021 due to a failure to appear and driver.
Well, but I mean, there are other ways, right? But the more concerning fact is that he's got an open warrant in a different state as well. What is that for? And how long has that been open?
We're only seeing for failure to appear. I saw earlier it was from 2017. So he's
It's
been
been
out.
open since 2017.
Correct.
I've never even been there.
I'm just telling you what they're saying. They're saying that you have also an open warrant from Kansas from 2017. I can't possibly give you a bond when you're wanted out of two different states, one for 6 years ago, man. Have Kansas not put a hold on him?
Not that I know of at this time. I can reach out to our central records to find out.
That would be good. You know, I would like to know whether they're gonna put a hold on him, you know? Has he waived yet? Do you know?
He has.
Okay, when did he waive?
That's correct.
Do you know what he's wanted out of Kansas for?
Not at this time. Dave was the one who told me.
So let's do this, because the cases that you're wanted out of Georgia, they're not the most egregious. You know, it's a suspended license and then a theft case. It's not the most egregious. My more concerning issue is that you're wanted out of a different state as well. So let's do this. What we can do, let's roll this to tomorrow. Can you, Amy, in the interim, if you can figure out, number one, is Kansas going to put a hold on him? Number two, what's he wanted for? If it's some kind of rinky-dink speeding, then I'm not worried about it. But if it's something serious, then I have issues, especially being that it's 6 years old. So let's do this. You know, it's a no at this point, pending what's going on in Kansas. So let's see what happens there. And then, you know, we can bring him back tomorrow and figure out. And I just need more information to be able to make an informed decision at this point. Okay? Do you have any questions?
Pretty much, I know somebody has been using my identity for the past couple of years because I was in Georgia, but.
And it's probably a good idea for you to do something about it and not just, you know.
I reported my identity stolen and I put out a theft report for it.
I don't know what to tell you, but before I set you a bond, and you got to understand, I can't just take your word for it, right? Right. I have a lot of people that try to sell me the sun, moon, stars, tell me it's little bunnies jumping in the woods, to what their cases are all about, when really. So let's figure out more information. We can bring you back tomorrow and see. Okay?
Thank you.
Okay, thanks, Shabbat.
And I also have waivers for Elijah Clark and Alana Gonzalez, who had originally sent her a bond, I believe it was like last week. Mother decided that they did not want to put it up.
Really?
So,
Oh, man, that sucks.
so we have her waiver. And
I'll just sign it. We'll begin. Thanks. Is Gonzalez on the docket today?
yes,
Set the bond at.
$1,500.
Hello,
Didn't want to make it.
I think, no. So when they were going to the bonding companies, they kept saying that even if they did it, that she would still want it. They were giving her a hard time. So I suggested that they go put the full amount up at 49 cents a cento. She told me that they were gonna do that. And then she called me, whatever day I sent the email the day before yesterday, indicated that they weren't able to do that, or they didn't want to do that, or whatever the case may be. So she's really just been
I
sitting there.
mean, it's a lot of money, you know, and
Because I explained it very clearly the first time I called Judge. It's unfortunate that she had to sit for a week. She could have been gone to Louisiana by now, I
Right.
believe.
um,
They assured me that they would before I signed the document that day.
okay, guys, thanks. Okay, Willie. Hey, man.
Judge, this was we're bringing back from last week. I'd approached about moving his monitor. Do you agree to remove it, but you want to bring him in to admonish him so that there's still no contact with the.
Come on up, Mr. Santana. So he's a truck driver, if I remember correctly, right?
You got it. That's the one that you.
The unlawful restraint, is it an is it an ex-wife? Is that
No,
her?
they're going through a divorce. They've had no contact since the inception of this matter. Whether the divorce goes through remains to be seen, but as of right now, they're separating for sure.
Or you think that there's, so
I don't think.
I need you to understand, Ms. Santana, come on up. I need you to understand that, so Willie says that you guys are going through divorce. It may not happen. I hope that you're not having contact with this person, because I've ordered you not to have contact with this person.
There's been no contact.
Don't. If I find that you're having contact, and I don't care whatever mean it is, I'm gonna throw your butt in jail. Do you understand? It looks like to me like you're having contact with her. Mannerisms are a big tell, Mr. Santana. And your mannerisms tell me that you're having contact with this person. I hope and pray that you're not, because if I find that you do, I'm gonna light you up. Do you understand? No means no, and I don't care what is going on in your life. I don't know, Willie. Because I think he's having contact with her, you
Judge,
know?
there's been, I think in this case, had there been, because she's still, based on my understanding, the state has had contact with her.
Well, I don't care if the state has contact. I don't want him to have
No, I
contact.
understand that, but I, through the calls that did not appear, and her agitation level with them is pretty high that it has been, I think they, the board would receive no.
Your Honor, if I may, when speaking with the complainant, she advised that she'd be comfortable with an intermediary. She does not want contact, but she'd be comfortable with an intermediary for the purpose of their children, but that's the extent that she's willing to.
Last time you talked to her.
So the last time was November and we were unable to get a hold. I can reach out now
No.
and try right now.
Yeah.
Yes, Judge.
I mean, I want to know that he's not having contact with her before I take that thing off, you know? So let me make sure. And if so, I'll take it off.
Yeah, I'm pretty comfortable with it because he's out of town.
We'll see.
He can't do it.
There are many other ways that someone can reach. Take a seat in the jury box.
They were unable to get in touch with her. And Judge, so given that we're unable to get in touch with her, we're not opposed to removing the GPS. We just,
No,
we
because
just want to keep the no contact, Your Honor. That's the main thing is she wants no contact. We want to respect that. But otherwise, I mean, we don't have any indication she's not getting in contact with us about any further incidents and we can't get a hold of her now. So,
how many times have you reached out to her?
so we reached out to her.
One today.
The last time as well, last time he told me I reached out then, and then today I reached out again. I even tried reaching out to her emergency contacts on her driver's license and nobody's answering to get a hold of her.
Judge, I firmly believe that had there been an issue, she would have been in touch with the state. He's a trucker, he's moved out, he's living.
This is a reality check most defendants don't fully grasp. In Texas, DWIs follow you forever. They don't disappear. Every future stop, every future smell of alcohol, every refusal becomes leverage against you. This judge is spelling out the roadmap straight to prison if behavior doesn't change. Be honest, do warnings like this actually work, or do people only realize it when it's too late?
In his truck. I brought him off the route.
But I mean, all I'm doing is taking off the device, right? But so you're saying he's sleeping in his car. I mean, what?
Well, I mean, I brought him off route because I thought this was already agreed to that we were gonna do this last week and brought him in to admonish him to maintain no contact, which he's already been doing.
Mr. Santana, come up. Do you have an offer in this case, Willie?
Offer.
Can you put an offer in this case?
We're gonna be able to look at it, Your Honor.
I will reluctantly take it off, but I want you to understand that you're not to have contact with this person. If I find that you do, I will issue a warrant for arrest. I'm going to put you in jail. Do you understand? No means no. I don't care what's going on. I don't care who. If you want to have any kind of contact with her, you must use an intermediary, someone else to use to contact
And
her.
they have one. They have an intermediary.
Who is it?
It's the daughter.
Yes, Judge, it's the daughter.
All right, Mr. Santana, good luck. All right. Okay. All right, Willie.
Thank you, Judge.
You got it, man. So is this true? You got into college? Wow, I'm so proud of you. That's so great. What are you going to be doing? That's awesome. Have you started yet, or when do you start?
Not when I start. I'm doing them online.
Okay, that's okay. Look, you got to start somewhere. Start small, and then you just build up, and then at some point it'll just get bigger, better, and then just keep at it. It's going to be hard. It's not easy, but if it was easy, everybody would be doing it, right? That's why the more difficult something is, in the long run, the better pay you get. Just keep up. If you ever have any issues, if you need help, just come back to us. We'll help you with whatever you need. Really, just stay with it, stick the course, and just keep it up. Okay? You're doing great. And remember, patience is key because you're going to get upset. Just don't take it out on anyone. That's it. All right? Great job. Okay. Thanks, Josh. Mr. Badamosi, you're charged with failure to stop and give information, leaving the scene of an accident without exchanging information. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yeah, I apologize. Does the last name start with a G?
Correct.
Okay, I just wanted.
D.
Okay, correct. So on October 16th, 2024, at approximately 2:05 PM, the officer was flagged down at an intersection of Huffmeister Road and Hempstead Road in reference to an FSGI. Upon arrival, the officer spoke with the complainant, who stated he was parked at a Valero gas station and that he observed the defendant display irate behaviors. The witness observed irate behaviors towards the complainant, who expressed fear for her safety. A witness stated the complainant was attempting to exchange information, and the defendant did not attempt to exchange info and left the scene. The witness tried to follow the defendant approximately 3 miles from the scene when he saw an officer and flagged him down. The officer made contact with the defendant, and the defendant was reluctant to provide identifying information, but then identified himself by name and date of birth. The defendant admitted to being involved in an accident and that the complainant's vehicle had minor damage. The defendant made a false statement that the accident occurred at Huffmeister and Hempstead, and the defendant stated he asked the complainant if she was okay. The defendant was released at the scene, and the officers then met with the complainant at the gas station, who stated she was driving southbound on Huffmeister when she was struck by the defendant's vehicle. The complainant pulled into the gas station, and the defendant began striking her window and became irate. The complainant requested the defendant's insurance information, and the defendant refused and left the scene. The complainant stated the defendant did not ask if she was okay, and the estimated damage was $970.48.
Okay. Have you run his license?
I'll run it right now, Your Honor.
Please. Mr. Badamosi, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. If you do not have a Texas driver license and liability insurance in your name, then you're not allowed to drive, and that is also a condition of your bond. Do you understand?
Yes, sir.
It's eligible, Your Honor.
Hey, file those conditions, please. Do you have the ability to hire a lawyer, Mr. Badamosi, or did you want to apply for an appointed lawyer?
If we could actually do this now, I
Don't. Just, I have a bunch of, well, not a bunch of days. I have DAs here. Whatever you say, they're going to use it against you. It's best that you just don't say anything now. You need a lawyer in this case. Don't, it's, you could end up with a conviction. You're looking at up to 6 months in jail and or a $2,000 fine. You need a lawyer to represent you in this case. So you can either hire one or you can apply for a court-appointed lawyer one, but you have to qualify for an appointed lawyer. If you'd like, I can give you an application and we'll see whether you qualify or not.
Yes.
What would you like to do?
Fine.
Okay, I need to know everything about you. I need to know how much money you have coming in. I need to know whether you have a spouse that has money coming in, what kind of car you drive, what house, money in your bank account. I need to know everything about you, and then I'll see whether you qualify. Deputy Miranda is going to give you an application. I'll have you sign a receipt with the,
So I go ahead and pay it for an attorney. I don't have to do all this. I just go ahead and hire the attorney and stuff.
right. If you wanted to go hire a lawyer, what we would do is I'd have you sign a receipt with Ramona, would get you out of here, and then when you come back, just have a lawyer.
I'll take the, I'll get mine.
You're going to go hire. Okay, so just bear with me. So I need you to sign our bond conditions. I'll have you sign a receipt with Ramona. Let me just have you take your seat in the jury box, and I'm gonna get your bond conditions. We'll have you sign it, and then after that, you'll be free to go. Okay? Mr. Smith, you're charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 5th, 2025, a University of Houston student found the defendant sleeping inside a campus building on the 4th floor and believed the defendant was not a resident. The student alerted the on-call desk attendant, who called campus police. Campus police made contact with the defendant, and after running him through TCIC, gyms, and locals, found an active issued campus-wide criminal trespass warning from May 16th, 2024. The officer had previously found the defendant inside a different building on the campus, and these buildings are only accessible to students and staff. The defendant is neither staff nor student. The defendant was then detained.
Right. Mr. Smith, I'm going to find that there's probable cause to go forward with the case. Now going back to University of Houston. Do you understand? Don't. If you need a lawyer, I can give you a lawyer today. You can tell the lawyer, but I don't want you going back unless you're an active enrolled student there. You're not to go back to any part of U of H. Do you understand? If I find that you violate these conditions, I'm going to put you in jail. No more PR bonds for you. I'm also ordering you not to be in possession of weapons as well. Understand? I'm not asking for much. Just don't go back there. If you need a place to sleep, if you need a place to go, we can find that for you. Just don't go back there. All right. I'm gonna stop. Don't. I'll have you, if you want a lawyer, I'll give you a lawyer today. You can tell the story. You do your side to the lawyer. All right. I need you to fill an application for me, Mr. Smith. So Deputy Miranda is going to give me an application. I'm going to have you sign a reset with Ramona. I will have you take a seat in the jury box while we get your bond conditions. Do not leave until you sign our bond conditions, though, and then I'll find you a lawyer here. All right? Mr. White, you're charged with driving, I guess, with a false driver's license. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
I apologize. Who's this defendant?
White.
White. Okay. Okay. On February 4th, 2025, officers responded to a possible fraud at an AutoNation in Harris County, Texas. And the officers met with the sales manager who informed them that a black male had arrived at the business and attempted to purchase a vehicle with a fictitious driver's license. The manager provided a copy of the driver's license provided to him, and an NCIC TCIC search was done on the driver's license and returned a photograph of a Hispanic male. The sales manager said that was not the same person who had provided the driver's license the previous day. The defendant had provided a salesperson a copy of the fictitious driver's license the day before when trying to purchase the vehicle online, and a salesperson thought it was suspicious when the defendant arrived on the 4th, having provided the driver's license of a Hispanic male and on the day before. The salesperson asked to see his ID, and he provided a paper copy of the same driver's license, although it looked like he had placed a photo over the original photo on the license he had sent the previous day. The defendant could not produce the original driver's license. The officer made contact with the defendant, who admitted the driver's license copy he had provided was not him, although he stated it was him in the photo on the paper copy of the driver's license. The defendant had his real driver's license in his pocket, as well as the doctored paper copy of someone else's driver's license. The defendant also had a copy of the original document he had sent the previous day.
Mr. White, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to pick up any new cases, not to be in this kind of behavior again. I will do everything in my power to protect my community. If I find that anything dubious is going on, I will revoke your bond, put you in jail, and I'm going to make your bond sky high. Do you understand? Can you file no engaging in like behavior, please? No contact with any of the complaining witnesses in these cases as well.
Yes, Judge.
The weapons as well.
Yes, Judge.
Mr. White, do you have the ability to hire a lawyer? I'm going to have you fill out an application. I will take a look to see whether you qualify. Don't endanger my public by any means. Do you understand? All right. I'll get with Deputy Miranda. Do not leave until you sign our bond conditions.
This right here is a huge courtroom moment. Bond revocation is not a slap on the wrist. It means the judge believes the defendant violated trust. When a judge orders no alcohol and you pick up a DWI, that's game over. Quick question for you watching. Should rehab enrollment after an arrest carry late, or is it already too late once a new charge hits?
Mr. Mendoza, you're charged with failure to stop and give information. This is a Class B misdemeanor. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement. They're offering you 3 days in jail with credit for the 2 days that you've done. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. The proverbial slap on the wrist that we were doing today. Look at me. The proverbial slap on the wrist. From now on, you are facing a minimum of 30 days in jail. So this, no more. And if you're not in this country with permission, and you do any more than 4 to 6 hours, you will probably get an immigration detainer. Do you understand?
Yes,
If you do not have a license and liability insurance, do not drive. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty to this offense, you can never change this. Is this what you want to do?
Yes, yes, Your Honor.
How do you plead to the offense, guilty or not guilty?
Guilty.
I'm going to find you guilty, sentence you to the agreement. Good luck to you, sir. You are Christopher McCormick.
Yes, sir.
Mr. McCormick, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Yes, Judge.
On February 4th, 2025, the officer was dispatched to a Lowe's in Harris County, Texas regarding a theft. The officer made contact with the complainant, who advised he stopped a male who intentionally passed all points of sale with merchandise. The defendant had placed items in a cart and proceeded to exit the store. The total was $714.88.
Got it. Mr. McCormick, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to go to any Lowe's whatsoever for any reason. If I find that you go to Lowe's, you pick up a new case, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand?
Sorry.
Do you mind filing those conditions, Mr. Alex? Tell me, do you have the ability to hire a lawyer?
No, sir, not at this time.
I'll have you fill out an application. I'll see whether you qualify. So Deputy Miranda's going to give you an application. I'm going to have you go to Ramon and fill it out, and then we'll have you take your seat in the jury box. Okay? Do not leave until you sign our bond conditions. Good morning, sir.
Good morning.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 6, 2025, the officer was dispatched to an intersection in North Houston of Roslyn Road and Little York Road regarding a major crash. The officer made contact with the defendant and observed watery eyes, slurred speech, and improper balance. The officer further observed a strong odor of marijuana. The defendant stated he was driving from his grandmother's house, turned north, and lost control of the vehicle. The defendant stated he had not been drinking, but had smoked marijuana and had marijuana in the vehicle. The officer observed a burnt marijuana cigarette on the crease of the defendant's right ear, and standard filter sobriety tests were performed. HGN 0 out of 6, walk and turn and one leg stand were unable to be completed. The defendant was read to DIC and consented to blood.
All right. Mr. Montalvo, I'm going to find that there's probable cause to go forward with your case. Have you any prior DWIs?
No prior DWIs and his eligible license.
All right. You have a lawyer. Because you have a lawyer, I will waive your appearance so you don't have to waste your time coming to court. But I am ordering you not to consume alcohol or illegal drugs. I'm going to test you. If I find that you continue to use, I will revoke your bond, put you in jail. Do you understand? Just stay in touch with the lawyer. He'll tell you when you have to come back. Don't pick up any new cases and just behave while you're out there. Do you understand?
Yes, sir.
All right. I'm going to have you sign a reset with Ramona. We'll have you get with Fleischer for your bond conditions. And after that, you guys are free to go.
Thank you, Judge.
Okay? You're Christopher Wilkins.
Yes, sir.
Wilkins, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On May 20th, 2024, officers were dispatched to the address of defendant's stepfather. The complainant was stated he confronted his son about missing items. The complainant was told the defendant to get ready for rehab. The complainant was noticed his jazz bass guitar was missing and observed his neighbor's cameras, which showed his son to leave the house. The total value of that guitar was $480. That was all I have on this one, Your Honor.
Do we know he did it?
Your Honor, it stated that there was.
So dad is saying there are several items missing from the house.
Yes, Your Honor, including a guitar.
A bass guitar.
Bass guitar.
Anything else?
Yes.
Does dad call the cops on his own son?
Oh, Your Honor, it was.
Stop.
Oh, my fault.
Stop. Don't say a word. Are you losing? So why talk?
I'm not sure how the police were contacted here, Your Honor. It just says that they met and spoke with him.
Another report written like it's just going through a drive-through.
So, Your Honor, the only thing I would say is, just based on the events, the defendant had initially declined any of the allegations, but later told his mother that one of the items that was stolen, which was a bicycle, was later stolen from the defendant when he left it at his store.
But here he's charged with a bass guitar. What the? I have a pet lizard named George. Really? Mr. Wilkins, I'm going to find that there's no probable cause to go forward in your case. This life is a very short life. And when you start racking up convictions, it really hoses you. It's really hard enough as it is as a black man in today's society. And when you start racking up convictions, especially theft convictions where you're branded a thief, do you think it helps? No. It doesn't. Get into school, get some knowledge, get a degree, find something to do and make a lot of money. That's what life's about. Not ending up in court with a theft charge. You know what I mean? If you have a drug problem, address it before it becomes a real issue and it takes a hold and grabs you by the boo-boo. You know what I mean? Plenty of people in there. We don't need any more. Please. What happened with upstairs?
We're gonna go on a 15 months deferred out here. And it's gonna get resolved.
They're gonna dismiss that one in exchange for this one?
And no.
And the weed? Got it. Okay. You know, there's not many times that you're going to be afforded this kind of deal where they're going to dismiss a felony in exchange for a plea on a misdemeanor. So I would be very, very careful. If all this stems from self-control or usage of dope or alcohol, I mean, really, there's some people when they drink, they become the life of the party. They're happy, they're fun to be with, they crack jokes. And then there's some people that turn into the devil incarnate. If that's you, then this should be a wake-up call. If it's not, what's it going to take? 25? You're charged with two very serious offenses. You have the assault down here, you've got the assault upstairs. They're going to dismiss that felony assault in exchange for this one. You're entering into a very serious probation where it's a 15-month deferred. This is a type of agreement where if you complete it successfully, you do not end up with a conviction on your record, but it's not dismissed. If you complete it, there's no conviction, but you can't tell people it was dismissed. It's not dismissed. Just you complete it successfully, you don't end up with a conviction on your record. You need to understand that there's still an affirmative finding of family violence. You pick up another one of these, you're looking at a third-degree felony, another 2 to 10 at the penitentiary. Do you understand? You can also never own a gun or ammunition as a result of this plea bargain agreement as well. Do you understand? Is this what you want to do? You give up nearly every right known to man by entering into this agreement saying, look, I'm going to make it, and if I don't, you can put me in jail for an entire year. That's the agreement that you're entering into now. So for you to complete this successfully, you must do a batter's intervention prevention program. This is a tough one. This is a class that you have to attend once a week for 18 weeks. If you miss it, they're going to kick you out of the program. If you get kicked out, we issue a warrant for your arrest. We'll have a hearing here to see if you violated. No drugs, no alcohol. You will be tested like crazy to ensure that you're not using. You must also do a TRAS. This is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill them as well. 20 hours of community service, $100 one-time donation to the family violence provider, no threatening or harassing abusive contact with Mr. Cockrell. Do you have children? I think that in lieu of community service, I would like to do a parenting class. And if she does a parenting class, then I'll waive the community service. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you're stuck with this until you complete it successfully or it gets revoked. Do you understand? I like to reward people. You know, I like to encourage people to do well. And what I normally do is if you do well in this agreement, if you don't test positive for dope or alcohol, you get all your classes done and you're nice to everybody, I'll take you off in half the time.
Okay.
So you can be done in half the time. If most, just be nice. Don't pick up any new cases and don't use. You understand? Is this what you want to do? How do you plead to the offense of assault of a family member? Guilty or not guilty? I'm not going to find you guilty now, Miss Loyola. I'm going to wait essentially for 15 months to see if you're able to comply with this. As part of this agreement, the possession of marijuana will be dismissed and your other case upstairs will also be dismissed as well. Do you get child support for the children or? Okay, cut her fees. It's never about the money. I don't care about the money. I care about you doing what you say you're going to do and showing up and doing it on time. The worst possible thing you can do is either pick up a new case or abscond. You just take off. That's an instant warrant in this case. You understand? So if you ever have any problems, come back. We can always work through it. We can talk about it, but just doing nothing and taking off, it's the worst thing that can possibly happen. All right, so I'll follow the agreement, send it to everything. Good luck to you, ma'am. Good morning, Ms. Blewett. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. Okay.
Thank you, Judge. On March 31st, 2025, in Harris County, Texas, officers were dispatched to an assault in progress call. The officer met with complaining witness one, who stated that he, the defendant, and the other complaining witness were in a polyamorous relationship. The first complaining witness stated that the defendant had sent numerous texts and calls and showed up unannounced at the residence. The first complaining witness stated the defendant struck him in the face while the defendant had a phone causing pain and a tooth to become loose. The second complaining witness stated the defendant arrived at the residence, and while complaining witness one was trying to calm down the situation, the defendant struck complaining witness one in the face, and in the process of breaking the fight, the second complaining witness was struck on the shoulder, causing pain.
But we only have the assault on the gentleman, correct?
But the assault's only on the, I'm sorry?
The gentleman.
I believe so,
You
yeah.
only got one count.
Yes, Your Honor.
Okay. Ms. Blewett, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you, there's a protective order that has been issued in this case. You need to get to know it. If you do something to violate the protective order, the state can and probably will file additional charges against you. Do you understand?
Yes, sir.
I'm ordering you not to have any contact with this person and not to be in possession of any weapons. If you violate this, I will revoke the bond, put you in jail. No more PR bonds for you, man. Do you have the ability to hire a lawyer?
Court appointed lawyer, court appointed.
Do you have the ability to hire a lawyer? Okay, I can have you fill out an application. I'll take a look to see if you qualify. I need to know everything about you, how much money you have in the bank, how much money you work, and I'll take a look if you qualify. I'll have you sign a receipt. Victoria, Deputy Miranda's going to give an application, and I'll have you take your seat in the jury box. Do not leave until you sign our bond condition. Can you file no contact, no weapons, please?
Yes, Your Honor. So no contact, no weapons?
Yeah. Good morning, Mr. Delaney. Sir, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Judge. On March 31st, 2025, in Harris County, Texas, a law enforcement officer responded to a trespass at a gas station known for being a drug trafficking hotspot. Law enforcement officers witnessed surveillance footage of the defendant making multiple hand-to-hand transactions and throw something in his vehicle when the law enforcement officers originally approached the gas station. The law enforcement officers detained the defendant and approached the vehicle and witnessed 2 sacks of marijuana on the passenger floorboard area in plain view. A probable cause search was carried out, and the officers identified the 2 sacks on the passenger floorboard as marijuana. The total weight of marijuana was 76.37 grams.
Mr. Delaney, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you not to go back to this gas station. Do you understand? I'm also ordering you now not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will put you in jail. Do you understand?
Good.
No more slinging. Do you understand? What do you do with yourself these days? Do you have a full-time job?
I'm doing application right now. I have an interview tomorrow.
Good. I'm bringing you back in 2 weeks, and I want to see that you have a full-time job. Do you understand? If you come back and you've done nothing, it's not going to go well. And I'm telling you, I'm going to drug test you within the next 50 days. If I find that you continue to use, it's not going to go well for you. You understand? All right. Did you want to apply for a court-appointed lawyer? Okay. Deputy Miranda's going to give you an application. I'll have you sign a receipt, Victoria. You will then meet with Fleischer for your bond conditions. I'm also ordering you not to be in possession of weapons as well. Do you understand? Okay, come on. What, you said 15?
He obtains GED.
What's
He
your,
obtains GED.
Yeah, but hey, 15?
Oh, I'm sorry, Phillips is on page 15.
Yeah, okay. Mr. Phillips, you're charged with failure to stop and give information, leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Judge, on September 1st, 2023, a law enforcement officer responded to failure to stop and give information call in Harris County, Texas. The law enforcement officer made contact with the complaining witness, who stated that she was pulling into a parking lot of a corner food store and observed the defendant's vehicle reverse into her direction quickly. The vehicle then rammed into the rear driver's side of the complaining witness's motor vehicle. The defendant's vehicle then quickly shifted into drive and fled the parking lot. The complaining witness took a photo of the rear of the defendant's motor vehicle after the accident and provided the license plate to the law enforcement officer. Law enforcement officer found the motor vehicle registered to an address less than a mile away and traveled to that address and made contact with the defendant. The defendant stated he was at the food store with reversing out of the parking lot and struck the complaining witness. The defendant stated he fled without providing information because he did not have a driver's license. The defendant was identified with his Texas ID.
So can you run his license, please, just to make sure?
Yes, Your Honor. I'm just not showing a driver's license number, so I'm not sure if he is part of the license since then, but we don't have it in our system.
If you do not have a license, do not drive. I don't care what's going on in your life. I don't care that you have to go to work. I don't care that a baby needs to go to the hospital. I don't care there's a burning building and you need to save 50 kittens. If you don't have a license and liability insurance, do not drive. You will be signing an affidavit with me today. This is the promise that you're going to make, that you're not going to drive. You cannot justify getting into a car for any reason. And if you do, you can be facing an additional 6 months in jail on a contempt charge. Every time you drive, it's an offense in and of itself. Do you understand? What do you do with yourself these days, Mr. Phillips?
I work and take care of my little sisters. My dad had recently passed away.
You have a full-time job?
Yes, sir.
Did you graduate from high school?
Yes, sir.
Okay. Did you want to apply for an appointed lawyer?
Yes, sir.
Okay. I need you to qualify. I need you to fill out an application. I'll take a look to see if you qualify. I need to know everything about you. Do not drive, Mr. Phillips. If you want to drive, go get a license, get insurance, show me that you have these, and then we can talk. But until that point, don't do it. There's going to be HE double hockey sticks to pay if you do. You understand? All right, come on.
Robert Shelby and the holdover, you wanted to, Bill Stratton had to leave. You wanted to.
You mind? Yeah, please. So I'd like to do PC. I just want to know, because it's a DWI second, there's also an evading. If you could just give me a brief rendition of what happened, please.
Yes, sir.
When he comes out.
Yes, sir.
Morning, Mr. Shelby.
Morning.
So your lawyer was here before I got here, and he had to leave to go to a funeral. So I wasn't able at that time to do conditions, but I want to put bond conditions on you because you now stand charged with a driving while intoxicated, second offense. You're also charged with evading arrest in a motor vehicle, which that one is a third-degree felony. You're facing up to a minimum of 2 years, maximum of 10 years in prison into Texas in the TVCJ. So can you please give us, you have the right to remain silent. Anything you say can or will be used against you, sir.
On April 3rd, 2025, in Harris County, Texas, an officer observed the defendant's vehicle traveling 117 miles an hour using a rear antenna radar. The officer observed the defendant weave between vehicles in an unsafe manner, and a traffic stop was attempted. The defendant passed an available exit with no indication of stopping and ran a red light. After a 20-minute chase, officers stopped the defendant's vehicle using a pit maneuver. The officers moved the scene to a parking lot, and upon contact with the defendant, the officer noticed glossy eyes and bloodshot eyes with an odor of alcoholic beverage. The defendant was identified by his Texas driver's license, and standardized field sobriety tests were conducted. The officers witnessed 4 to 6 clues on the HGN, failed to keep balance on the walk and turn. The defendant refused the one-leg stand. The officer is a drug recognition expert and observed signs of drug intoxication. The IC was read, the defendant refused, a blood warrant was executed, and blood was collected.
Can you run his license, please? See his license.
Yeah, he doesn't know. So
at 117 miles an hour, Mr. Shelby, I'm now taking away your privilege to drive. I'm appointing you, Mr. through it here in the interest of justice now because your lawyer's gone to a funeral. But I'm putting these bond conditions on you now. And I want you to know that I will do everything in my power to protect my community at all costs. Do you understand?
Yes.
You are not allowed to drive
Yes.
at all. You will be signing an affidavit. This is a promise that you're going to make to me that you're not going to drive. And if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to put a monitor on your ankle so I know that you're not consuming. You will be tested for drugs and alcohol. If I find that you're using, likewise, I will revoke your bond and put you in jail. If you have a problem with drugs or alcohol, now is the time to address it. Because if you don't, and I see that it becomes a problem while you're on bond, I will address it for you. And I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
I am now sending notice to DPS that you're not allowed to drive any vehicle that's not equipped with an ignition interlock on it. Every officer in this state will know that if you're pulled over and you don't have an interlock on whatever car you're driving, they will arrest you and put you in jail. And that is a violation of your bond condition here. Do you understand?
Yes.
You're not allowed to drive any vehicle that doesn't have an ignition interlock on it. As it stands now, I'm taking away your privilege to drive, so you're not allowed to drive. You will get a device on your ankle so that we know that you're not consuming.
No, sir.
So he's not required to get the interlock unless you rescind that order for him not to drive?
Correct. You will get a STRAM device within 3 days. Within 3 days of your release, you will be required to get a STRAM device. And if you fail to do it, then your bond is going to be revoked. As it stands now, you haven't made bond on the DWI in your felony case. That's why you're still being held now.
That's a scram device.
It's a device that goes on your ankle so that we detect through perspiration whether you are consuming. All right. I just wanted to bring you out to give you notice of the condition that we're placing forth on you now. All right? Okay. All right. So we need him to sign this and then sign with each and then. All right. Thank you so much, Carl. I appreciate it. You sure you want to do this?
As we talked about probation, we talked about the
You
different
have no
choices he has.
convictions. You have no as far as I see, no convictions. Now, after today, you're going to end up with a conviction on your record. From now on, you're looking at 90 days in jail for any new cases that you pick up, you know?
Yeah, the choice is, you can get the defer, you can get the probation that we talked about, but you decided to do the time.
When you plead guilty to something, it goes on your record and it stays there for the rest of your life. You can never take it off. And it will affect you when you try to get a job, try to buy a house, try to get a car, a loan for something, try to get an apartment. So that's what I'm saying. I mean, you're old enough to know that.
I was lost when you was like 90 days at the.
No,
I was lost because.
No, what I'm saying, you pick up anything else in the future from now on, it's a minimum of 90 days if you take this deal, because they can enhance your punishment to a minimum of 90 days in the future.
You're not getting that as a time served deal. The judge
I'm
just
served
want-
here, but what I'm saying is, you don't want to defer to try to keep it off? You just.
So if you look at the computer, I've been to TDCJ before. It don't matter. It don't matter. I'm just gonna be honest with you. It don't matter.
I don't see, I only get access to Harris County because I can't get them to give me access to anything else anyway.
I
So,
understand, but I can tell you, and
Okay.
I had my time, I done did my lesson. So if time served, I don't have to go to jail. I don't have to look over my shoulder. That's fine with me. I walk a straight line. That just was a unfortunate happen with my problem.
you're charged with resisting arrest. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you've done. Like I said, this is going to go on your record. It'll be there for the rest of your life. You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you plead guilty, that's it.
I understand.
This is what you want to do.
Yes, sir.
How do you plead to the office?
I plead guilty.
I'm going to find you guilty. I'll follow it. Good luck to you, Mr. Pack.
Take
Take
care.
care. I can get you this piece of paper, go downstairs, so you don't have to make more copies.
All right.
I'll be with you.
I think the offense date was March the 30th, sir. So a little more.
No more.
Sure.
I'm going to test you 50 days from today.
Sure.
If I find that you continue to use, it's not going to go well for you. Do you understand?
Sure.
Do you have a job?
No, not at the moment.
It's time. It's time for you to start working and being productive. When you have too much time on your hands, you become self-destructive. That's what we don't want. I don't want you to pick up a 6th case or 7th case now within the next, that's it. I'm going to bring you back in 2.5 to 3 weeks and I want to see what you have done to get a job. If you've done nothing, you understand.
Yeah.
All right, good luck.
And he did let me know he has enrolled in HCC for the summer session of college.
That would be great. That's great. But if you're taking 6 hours, you got to do something else as well. If you're taking a full load, then great. The more schooling you do, the more money you're going to make in this life. Knowledge is power, and with knowledge, you get money. That's what this life is about, not convictions. Do you understand?
So,
good luck. Thank you. Yes, ma'am. All right.
I apologize, Judge. I was in court 4 and just sitting there for a while too.
Don't worry about it. You're good. We're glad that you made it. Did Stradley come here today?
Yes, he reset it.
He already left?
Huh?
He already left?
Yeah, he already left.
Okay. Because we need to do conditions. It's a second. It's a DWI second. We need to do conditions. And I know, but I still want to put conditions. He's going to bond out, I would imagine, right? No, but I'm putting conditions first. I want to get conditions so we get a guardian interlock and now, see. Yeah, I mean, I want to put conditions on, and if you can't say that we can give him someone in the interest for now, just for purposes of conditions. Okay. It's okay. Tom, hear you.
Tom, I'm gonna send you an email on this one. I think we've got it worked out.
All right.
Just let me know when you're ready, okay? Hi.
Thank you, Judge. I just wait here in the link.
Yes, ma'am. Good morning.
good morning, Judge. I'm here on an off-docket matter. Is that okay?
Yes, okay, of course. What's your cause number?
There's 2 and Judge, hang on.
I forgot my eyeballs too.
There's a DWI, and that's cause number 2556097. And there's a tampering.
This on Mr. Hernandez?
Yes, sir.
Are you representing him on both?
I am, and Judge, we just realized, I'm sorry, my staff, I just filed the notice of appearance on the tampering. We didn't realize he had 2.
We have you connected.
Okay.
It looks like he has an ice hole.
Well, yes and no, that's why we're in front of you. So he apparently posted maybe the PR bond here. ICE got him from the jail. He went to immigration. April 2nd, posted a bond there. But we've got 2 warrants. I believe these warrants are holding him. And so didn't know if, I think Harris County maybe has 10 days. I don't know for sure. They have a certain number of days.
What happens is that you don't get notice, or I guess we didn't realize that he's in immigration. We assume that he's out, he's gone on the lam.
Right.
So
And they didn't
we
have
issued
a
a warrant.
warrant to tell you, Judge,
So he's made bond on the immigration case?
Yes.
Okay,
Yes.
so I can reinstate these bonds now,
Okay.
but as soon as he gets out, he needs to come here immediately for bond
Of
conditions.
course, okay.
So we need to set a day.
What's the case number?
You ready?
Yeah.
It's 2556097. There's 2. I'll reinstate it now, but if he's not here by the next setting, let him know that I'm gonna end up revoking him because he needs to come here for bond conditions. I guess just pick if you want like maybe a week or so.
Okay.
Yeah.
Thank you.
Yes, ma'am.
Appreciate it.
Of course. Did you get the cause number?
Yes.
There's 2.
Anthony Hernandez?
Yeah, please reinstate both.
Yes, sir.
Yeah.
Within 150 days old.
Yeah, where are we headed?
We're waiting on the RIP call and the 911 call. I believe the state has sent an escalated request.
Yeah, we've requested the 911 call twice, Your Honor. I'm not sure why it's not in yet. I would just request if we could just have one more sentence while I try and reach out and hound somebody to get the 911 in. It is.
Subpoena them to come to court. That's what I would do, so give them 10 days, subpoena them to come to court. And then If they provide it to you, then great. If not, then, but if they can't get you just the 911, then that's as simple as possible, okay?
Yes, Your Honor.
So a 10-day discovery hearing. Yes, ma'am.
Thank you, Your Honor.
Sure.